Now, first, we need to understand the background of this legal proceeding. There was a judgment that was given by the High Court on the 9th of February this year, and which judgment was based on a petition that had been lodged by some people claiming to be supporters and members of Jubilee Party, and by extension therefore Azimio, and who sought principally that the Speaker's ruling that had been made in October 2022 be nullified for the reason that, in their view, the Speaker mistakenly granted the position of majority leader to the Kenya Kwanza Alliance as opposed to Azimio. And of course, among the other issues that arose in those High Court proceedings was the periphery question of whether the Speaker of the National Assembly can hold his position as well as that position of other political parties, including that of the Kenya Kwanza Majority Alliance. Now, the matter came up for judgment on 9th of February this year, where the High Court agreed with the petitioners and nullified the Speaker's ruling that had slotted the Kenya Kwanza Alliance as the majority party in the National Assembly. And of course, among the other things that the court had talked about without making a finding was that, in the High Court's view, it was not proper for the Speaker to hold the two positions. But the court went ahead and did that as a by the way. In other words, it's called obiter dictum, where there was no final decision made on that matter. Now, going forward, the National Assembly, which was the substantive party before the High Court, was aggrieved by the decision of the High Court and appealed to the Court of Appeal. Among other appellants who were aggrieved by the High Court decision, including political parties that had been adversely mentioned in the High Court judgment. At the Court of Appeal, other than filing the substantive record of appeal, the parties, including the National Assembly, also filed an application for stay, seeking principally to stay the High Court decision that had nullified the Speaker's decision on the majority leadership in the House. Now, before that application for stay could be heard, the Speaker of the National Assembly went ahead and made a subsequent, which I would want to call a second ruling, on the subject of the majority leadership in the House. And in the Speaker's view, the position remained the same, being that based on the prevailing circumstances that February, still the Kenya Kwanza Alliance remained with the majority members in the House. And that ruling of the Speaker stands to date. Nobody has gone to challenge that decision in court, and no court has pronounced itself nullifying or otherwise disagreeing with the position of the Speaker as to the current position or answer to the question of who is the majority in the National Assembly. Now, back to the Court of Appeal, the application for stay was heard and a determination was made on the 21st of March this year. And of importance to note is that the Court of Appeal took note of the fact that, although yes, there were disruptions in the National Assembly proceedings based on the High Court decision, those disruptions have not paralyzed the proceedings of the National Assembly. And therefore, in their view, the appeals that have been filed, which are more than 5 in number, against the High Court decision, cannot be rendered nugatory if the Court of Appeal were not to grant the stay. Because one of the fundamental grounds that had been raised at the Court of Appeal in seeking the stay was that the National Assembly proceedings were almost coming to a halt. But then the Court of Appeal disagreed with that, and it said, in any event, the National Assembly proceedings are ongoing despite the small acrimony that had been witnessed. The second issue that arose was whether the Court of Appeal ought to stay the High Court judgment based on its, by the way, notes on the decision of the Speaker to continue holding the position of the party leadership at the same time as the Speaker of the National Assembly. The Court of Appeal made a very interesting and correct decision that, in their view, the High Court nowhere in its judgment made a final order demanding that the Speaker either vacates office as the Speaker of the National Assembly or as the party leader of Ford Kenya or as a co-principal of the Kenya Kwanza coalition. And therefore, in the view of the Court of Appeal, there's absolutely no threat to the Speaker of the National Assembly because no decision have been taken by the High Court regarding his holding of the dual role as the Speaker of the National Assembly and a political party player in the Kenya Kwanza alliance. And therefore, the Court of Appeal said that if there is anything that then will arise, even including the would-be contempt proceedings, then those issues will be dealt then, as opposed to bringing those issues before the Court of Appeal. And therefore, the status is as follows. That one, the decision or the ruling of the Speaker made in February regarding the current state of who is a majority party in the National Assembly remains, and which is the Kenya Kwanza Alliance remains the majority party. Secondly, that the question of whether the Speaker should continue holding his position, one, as a Speaker of the National Assembly, and secondly, as a co-principal in the Kenya Kwanza coalition and a party leader of Ford Kenya, still remains that there's absolutely no adverse order that has been made requiring the Speaker to relinquish any of those positions. And therefore, we do not expect any confusion on what the Court of Appeal said, neither do we expect any confusion on the political leaders' position in the country as regards the Kenya Kwanza coalition, as well as other coalitions or players in the country. What the Court of Appeal said is that yes, it has noted that there are serious grounds of appeal that had been raised by the National Assembly challenging the decision of the High Court. And one of the grounds that have been raised is the question of whether the High Court would have been right in saying that when Kenyans go to the ballot, for instance, in this case, in August 2022, whatever decision they made regarding the MPs and their respective political party coalitions, that position remains static. In other words, it does not change at any point in time prior to the next election or in between until the next elections are held. Now, the position we've taken to the Court of Appeal is this, that decision or that thinking cannot be right, for the reasons that, first, the Constitution allows or grants a right of association. That at any point in time, a person or a political party has a right to associate with whichever person or party they intend to. And if you are to say, for instance, that if I associate with Kenya Kwanza or Azimio at the previous election being 2022, and I want to change my mind to associate with another political party or political coalition, that right is taken away by the mere fact of how I voted in 2022. That cannot be right. We're asking the Court of Appeal to consider other factors that then influence the right of association, which include, for instance, if a political party that had 50 members of parliament in the last general election, there are possibility that that political party or coalition can lose members of parliament in the following instances. One, and of course all of us know, that death is a reality. There are members of parliament who, in this regime, the 13th parliament, have passed on. If the coalition had 50 and 2 or 3 or 1 has passed on, does the number remain the same? The answer is absolutely no. Let me give another example. If a person is elected and that person goes, there's an electoral dispute in terms of a petition that is filed before the High Court, then the court grants that petition and nullifies that election. What then happens is that the coalition or a party that had that member would have lost a member. Are you saying that that number does not count, for instance? That cannot be the practical reality. Let me give another example. The Political Parties Act allows realignments, post-election coalitions. What does that mean? That if, for instance, you entered into a pre-election coalition, like in this case, the Kenya Kwanza political parties that were formed prior to the August 2022 general election, and the Azimio ones that had been formed again prior to 2022 general elections, post-election, the law allows parties to again realign and, associate with the new political players. In this instance, does it mean that then, if you want to enter into a post-election coalition agreement, you are bad because you must remain where you are, regardless of whether or not you continue associating with the ideals of that coalition? The answer is absolutely no. A person or a political party is allowed to shift depending on the political realities or the interests of that person or the political parties. And that's why, for instance, the law allows a coalition partner to withdraw from a political coalition. Let me give an example. NARC Kenya has withdrawn from Azimio coalition. Are you saying, therefore, that NARC Kenya has no right to associate with any other political party merely because of them having signed an agreement with Azimio pre-election? The answer is absolutely no. And therefore, the position, and we expect that then the Court of Appeal would consider this positively, the position is that a person having been elected on a particular political party have a right to associate thereafter with another coalition based on their interest at that particular time. And these are arguments that we are raising before the Court of Appeal. Happily, the Court of Appeal has ordered or directed that the appeals be fast-tracked, and we expect that the Court of Appeal will be able to answer those questions positively, as is expected. I want to make this very clear, that whereas the petitioners in the High Court had gone to court and sought specifically that the court does declare who is the majority and minority in the National Assembly, the High Court expressly dismissed that prayer. In other words, it declined to grant that prayer. And that then means that the High Court was alive to the fact that the only person who has power to declare or pronounce him or herself over who is the majority or minority in the National Assembly is the Speaker of the National Assembly. And therefore, when the court nullified the October ruling of the Speaker on majority and minority, the question went back to the same constitutional person with the Speaker to answer the question of who is the majority and minority. And what did the Speaker do? He looked at the prevailing circumstances, looked at the documents, including those documents from the register of political parties, and pronounced himself that Kenya Kwanza remains the majority. There's absolutely no court order that had restrained the Speaker from pronouncing himself as to is the majority or minority. In fact, what the High Court did is that it created a vacuum. By it nullifying the decision of the Speaker that had been made in October 2022, it created a vacuum, and therefore the Speaker had to fill that vacuum by himself again as the constitutional organ or person who has that duty and mandate to declare then who is the majority and minority. And therefore, there's absolutely no contempt on the part of the Speaker. There's no order that has been at all contravened by the Speaker, and we expect that there can be no other interpretation different from what I've stated because the court orders were in black and white.